Ladies and gentlemen, welcome to a special conversation here from Second Amendment Radio. We are joined in the studio today with Dr. Bill Robinson, whose voice you have heard on Homeland Security and Straight Talk and on Second Amendment Radio on the WYSL stations and also across the state on the web. It's our great pleasure to also have in the studio Second Amendment attorney Paloma Capanna, Esquire, and welcome both of you.
Thank you.
Thanks very much.
Appreciate you coming in, Doc, and putting this, helping us put together three roughly 20-minute segments together.
This is a special program. This has now been broadcast. So this is for our online friends, and be sure to tell your friends about the existence of these files and their availability online, because we have some important ground to cover today. Right, Bill?
Yes, we'll have these up on YouTube. You can fire up our Second Amendment website and find these three segments with Paloma, and you'll be able to fire up the Scope website at scopeny.org. And also, Paloma, your website is law-policy.com.
It is.
So we should have these three segments available on all three locations. And our Second Amendment show is 2ND, the number 2ND, amendmentshow.com. Anyway, so we wanted to start. Where do we start here, Paloma? We start at the beginning. In the middle of the night, let's start off. In the middle of the night, a law was passed. This SAFE Act, New York State SAFE Act was passed. We call it the Criminal Protection Act, the Unsafe Criminal Protection Act. That's what we've been calling it on our radio shows. And let's start off with your comments on how this happened, why it happened. You know what? And you've read the governor's book, and we can cover that, in the beginning here, this first segment. So go ahead, your time. Go ahead.
Well, let me put it this way. His middle of the night entrance was nothing like Santa Claus coming down the chimney.
No.
I mean, essentially, what happened January 13, 14, 15, a couple of years ago, was the biggest nightmare for the Second Amendment, really, since 1781. I mean, there just isn't a comparable minute, I think, in legislative history, either in New York or other states or at the federal level. The governor orchestrated, behind the scenes, passage of a 39-page bill that nobody had seen. And what's even worse, if you will, than the fact that he jammed it through on a message of necessity, which, we can talk about further, is that he just brags in his autobiography, recently released, about how he pulled it off and that this was absolutely the way to go about it. He learned his lesson with the difficulties he had passing the same-sex marriage bill. And so this tactic of his was literally waiting for the right political opportunity, which he saw in the Sandy Hook events, which occurred December 2012.
Mm-hmm. Yeah. Well, our problem is this. From the people I'm talking to, our Senator Joe Roebuck, we've had on the show many times and talked with him. He had, I think, basically a 20-minute notice to really study it, to look at it, and then have to vote on it. Some of the men, Bill know, Jay. Well, did he get a chance to vote on that, Doc? I'm not sure because he was just brand new. He was already sworn in, so he had. That's right, he did. I'm just so much has happened here. I got to backtrack.
He gave us some insight on the timing, of which there was none. I mean, essentially, the bill was just dumped. And I just circle back for just a minute here, Paloma. I'm a member of a not particularly exclusive club, that's the people who have never read Andrew Cuomo's autobiography. And I think you're one of 4 people who've probably actually read the book.
It's a very elite crew, just
I'm thinking,
a few of us.
I'm thinking you should get like the Bronze Star and the Oak Leaf Cluster for wading through that. But you seem to be suggesting it as rich with... would it be safe to say self-aggrandizing, self-congratulatory rhetoric about the passage of this?
Yes.
And there could potentially be a rich irony here, don't you think?
Well, there is. And when the book first came out, I was one of, 972 people, I think, who bought it in the first week. It was one of the worst releases of a political autobiography.
Worse than Hillary Clinton's, which is saying something.
She came in at 100,000 plus in her first week. So let's do this again. The governor was less than 1,000 copies sold.
Yeah, but those 100,000 were bought by the DNC, but that's another story.
Regardless who bought it, she demonstrated volume and moving off the shelf. What I think was really the surprise for me, I grabbed a copy in part because a big part of my day is opposition research. So I am almost more likely to read what is coming out of the left than what is coming out of our camp. I am assuming that we agree pretty well on the main principles. What I thought I was going to see in the governor's book was something carefully orchestrated and really nothing more than PR. That would have been the safe approach. It's certainly the Clinton model and even the Bush model when you look at, their respective books. But my feeling is that it really is Andrew Cuomo live and unedited, because it's of such a, if you will, limited literary value that at first you start reading it and you're thinking, oh my goodness, is there ever going to be any content? But then what you realize is this has to be his true inner voice of, I am king, I am responsible for everything. If I don't take action, no one else will. I mean, it's really very startling. And then...
narcissistic.
It is, but then there's this undercurrent of fear. And you realize that since the time he was a little boy, in his self-descriptions, he was afraid of bomb drills when he was an elementary school student, afraid of people protesting his father outside their home in Queens when he was an early teenager and felt like he was the man at the house and had to take care of people, afraid going through the divorce, that he was having a mental breakdown for a period of months, afraid when he got lost on a lake in a boat in fog and there was nobody else on the boat with him. I mean, when you really get through the whole autobiography, you've got this terrific collision between Andrew Cuomo, the overzealous, over-aggressive leader of the state of New York, and Andrew Cuomo, the person who is really very much afraid.
Mm-hmm. Is this not? You're an attorney, not a psychiatrist or psychologist. But
I'm
this
here
is
today just as a person, really, for an intimate cut on things.
Well, that's we like all those roles, but this is the characteristic, I think, of a grandiose personality, where you have you have this overcompensation that goes on, and I think this book could unwittingly provide tremendous insights into the job that we have to perform as guardians of the Second Amendment here in the state, and Second Amendment Radio, and you, Paloma, as a Second Amendment attorney, in safeguarding this God-given right that descended to us from through the expertise of our founding fathers.
Oh, I couldn't agree more. And candidly, I've quoted his autobiography in every lawsuit paper I've written since. He presents, if you will, from a legal standpoint, a bit of a headache, because he is really a client. He has attorneys, representing him in these cases, but he's really a client out of control, in the sense that, the lawyers are trying to carefully craft these legal papers, and then the governor goes and shoots his mouth off in an autobiography in manners that completely contradict the attorneys.
Of course, there is some limit there, because, of course, the autobiography is not under oath, so, it could be discounted by...
That might be worse. He should be held accountable.
Every attorney's nightmare, a client like Andrew Cuomo,
absolutely, right? Because we've got press conferences and interviews and so forth, so... a big part, I think, of the difficulty, if you were an attorney representing him or trying to defend him or trying to, and I don't think we're going too far here, or trying to keep the great secret of how the SAFE Act actually got put through. And then he goes and publishes this autobiography with all kinds of statements that amount to being a deep throat on the SAFE Act. What better whistleblower could I possibly have than Andrew Cuomo?
Yeah. Now, back to the actual SAFE Act that evening, I was started to get into with Senator Roebuck. We talked to his people, and Senator Joe Roebuck told me that one of his personnel, some of his help, asked the point man for the governor on getting this shoved down our throats that night, would this SAFE Act, the legislation, this new law, have stopped the two major shootings we had? Of course, the one in West Webster, with the firemen, and the one in Connecticut, right? And the point man told the truth. No, it wouldn't have stopped either one of those. Okay, now this was an emergency. This was a necessity being shoved down our throat that night. What was the term? Official?
Message of necessity.
Message of necessity. That's their official. It was a rush. Had to be done. Yet this law, and they admitted it that night. His point man admitted that it wouldn't have stopped either shooting. So there you go. So in other words, this was a con job to begin with from day one, right there that evening. And then the other issue is he's ranting and raving that night. The governor doesn't take 10 rounds to kill a deer. Well, New York state law, everyone that hunts in the state of New York knows that you can't have with a semi-automatic gun or any other rifle more than 5 rounds in your weapon, in your gun. You can't. That's the law. It's been law in the state of New York for 50, 60 years. And the state troopers have not covered him on that. The legal department, Eric Schneiderman, has not made that clear that it's illegal to have more than 5 rounds hunting. He's used that as a tool, as a scam, to mislead people.
And the Second Amendment, of course, has nothing to do with hunting anyway. So
yeah. But he's using that.
It's a straw man argument.
But you heard him rant and rave about that night. So he made a big Hollywood production out of nothing. It's been illegal in the state of New York to have more than 5 rounds in your rifle or shotgun, period.
So it's another demonstration of someone who knows nothing about firearms. That's not surprising.
Yeah. Clearly do not, right? And it's a question of which lawsuit do you want to talk about on that point, because the New York State Rifle and Pistol Association, of course, sued Governor Cuomo beginning in March 2013 over the assault weapons provision within the SAFE Act. And that case went up for oral argument to the Second Circuit Court of Appeals on December 9th. And that was really one of the things that I think was evident in the attorney's arguments, both for the state of New York and the state of Connecticut. Connecticut having a comparable law passed at a similar time, 2 hours. So there's the New York case, and then there's a comparable Connecticut case, and now they're both in front of the Second Circuit. And it was really evident from the two states' attorneys that neither of the two women were at all familiar with firearms, were not understanding the federal restrictions, even something as simple as federal disqualifying events, which have been around, some since 1968, some since the 80s, some since the mid-1990s. You've had a few amendments, but certainly for at least the last 20 years, you've had several disqualifying events at the federal level, including things like if you are a felon, good luck. You are not allowed. You have forfeited your Second Amendment rights. And so whether it's the governor or it's the attorney for the governor or papers submitted in writing on behalf of the state of New York, nobody seems to demonstrate any familiarity with either the federal system already in place or day-to-day law-abiding gun ownership culture.
Yeah, exactly. So that's basically, folks, that's what happened that night. You've got a general idea what Paloma's talking about, and what we're covering is the SAFE Act, the Unsafe Criminal Protection Act. What happened?
Just a second, Bill. I just want to pursue something a little bit more. So this was a nakedly political action. This was, I want to be the first kid on the block to have the big restrictive gun.
Yes.
In other words, try to cynically capitalize on the deaths of school children.
Yeah.
He had an opening, and that's what he ran through. And what's clear from the autobiography, right? So again, back to, this is not us being critical. According to the governor, many moons ago, when he was working down in Washington, D.C. for HUD, is when he first conceived of the legislation that we are now looking at. So it has nothing to do with anyone who has died over the course of the last 30 years.
Never let a good crisis go to waste.
Yeah. Absolutely true.
Yeah. Again, a con job. He slipped it in, and again, under emergency, this necessity business, which is a fraud. What he pulled off, he got away with it.
Just real quick, Paloma, if you could explain to the folks what the message of necessity was all about, what the mechanics of that were, how that worked.
Sure.
Just the basics of it.
Sure. I mean, under the New York State Constitution, we have this little wigwag of a detail that if a governor issues a message of necessity in writing, it suspends the 3-day desk rule. So under normal circumstances, the legislators are entitled to have a bill for 3 days before they cast their votes. The message of necessity suspends that. in the case of the SAFE Act, the governor's office did not release the bill until after 5 p.m. on the Monday, and this thing already was in committee within about 3 hours.
In committee, basically being tantamount to being passed.
There is no question, both from the governor's autobiography to the responses that we've received in lawsuits to some of our document demands, to the letters that were issued by Assemblyman Silver and Senator Skelos calling for the message of necessity.
Which was, of course, prearranged, a political calculation.
This was an in-house, closed-door, backdoor deal that they had set up ahead of time.
Right.
Without Bill Nojay, as an example, Assemblyman Bill Nojay knowing a thing about it or getting any quality information on it, Senator Roebuck and other senators on our side did not have a heads up on it. As far as the specifics, they knew something was going to happen. When I talked with Assemblyman Brian Kolb, who was the minority leader, I talked with him the night before or 2 nights before. I think it was either the night before or 2 nights before they passed this. He said that they got information that this is coming down no matter what. He told me straight outright, this is going to happen. And he can't stop it. Of course, he's a minority leader in the Republican Party. In the Assembly, what's he going to do?
But I think, I'm just going to give a little chuckle. We're not doing any outtakes here, people. So if I get the hairy eyeballs from Bill and Doc at this one. But, this business that it couldn't be stopped, it is a democratic process. And if you do take a look at the Senate rules, and you do think about the composition of the committee through which this bill had first to pass before going to the floor of the Senate, before going over to the Assembly, before getting to the governor to be signed, the composition of that committee was 13 Republicans, 12 Democrats.
Yeah, there you go.
So I do regret that I have to really put that question out there for the general public, because this point just has not really been brought forward. Where was our conference for this vote?
Yeah, well, Senator Nozzolio comes up, and he's been in question. Okay, and I'm saying it right outright. He's been on our side. We've given him an A rating in the past and things, but why didn't he? This is the heat I'm taking as a radio talk show host, and I get around the state of New York. We do our OPFOR training. We do a lot of things. So I'm running into people all over the state of New York, and they're saying, what happened to Senator Nozzolio? He had some muscle. He had some power there. And how come he didn't intervene? This is bugging a lot of people. It's still bugging them.
There are a number, and I have a little window on this process through Assemblyman Nojay, who's my business partner, and who also appears on our Second Amendment radio flagship station, WYSL. Suffice it to say that there are a number of our Republican assemblymen and senators who are, for want of a better term, I would say under the spell of Andrew Cuomo, that deals are made behind the scenes. It's corrupt. It's a corrupt process. And I think that Doc over here is alluding to something that we all have to kind of, unfortunately, be resigned to, and that is that we have to have our eyes open and hold these guys accountable for their actions or inactions every election.
Well,
and you can't sit out these elections. You just can't do it.
Yeah, in this case, this specific case with the SAFE Act, key Republican senators and key Republican assemblymen should have gotten the word out to us, so we could have made a lot of phone calls and had 400 or 500 people down there protesting or getting, right there on the spot. Not
Bill, I don't know if that would make a difference.
I know, but the point is we didn't even have a chance. We had no chance. This was a done deal behind the scenes, and they brought it out and they voted on it, and that was it.
Right.
So we didn't have a chance to counter this, and that's wrong. That's very poor government. That's not transparency, as the governor bragged about. Before he was elected, he would have a transparent government. He would straighten out the corruption in government, and we're finding out that he's done neither. In fact, he's adding to the corruption. And
we take it, too, I think, one step further nuanced. I mean, Senator Nozzolio represents me, and I think we do need to be sure to say he did vote no.
He did.
In committee. So it's not that he didn't vote no, but I think this also allows us to get into this question a little bit, though, of style. Because when you watch the footage, there's a video of that committee meeting that you can watch online. It's 24 minutes of a different bill, and then less than 1 minute on the clock the chair calls for the vote. Nobody says one word.
No discussion.
No, that's what I'm
nothing,
talking about.
right?
Yeah.
And I'm just imagining, I mean, if you're ever going to burn political capital, is it not at a minute like this where you would stand up, where you would protest? I mean, the Senate rules have ways that you can slow this baby down. In this era of social media, where our Second Amendment listeners are so well connected, so ready to be grassroots activists, I'm with Bill.
Yeah.
Because if the word had gotten out and that bill had gone live on the internet, Capitol would have been flooded.
Oh, they would have had thousands of calls, and I would have shot in my vehicle and went right down there. I would have shot.
For this,
3
yes.
hours and 10 minutes. I would have done 85 miles an hour on the thruway, got down there to be there, right, get in their faces.
You're listening to a special conversation with Dr. Bill Robinson of Second Amendment Radio and Paloma Capanna. We'll be back with more. This is an important conversation. Thanks a lot for joining us. We'll be right back. Thank you for joining us here online. A special conversation with Second Amendment Radio's Dr. Bill Robinson and Second Amendment attorney Paloma Capanna. Doc, take it away.
Yes, this is our second segment. We're going to do a total of 3 of these. We just wanted to educate, help bring our listeners and our active Second Amendment people up to date on what's going on, past, present, future type of thing. So it's just a simple chit-chat with us, but we're putting out a lot of quality information, a lot of quality facts here, accurate. You know, the facts are supposed to be facts and accurate and truthful, but we are doing our best to be as accurate as possible and to get the truth out and fight the disinformation that's out here. So we're having this session here with Paloma Capanna, a Second Amendment attorney. And I should mention on this segment here, Paloma, you have your office is in Webster, New York. You work out of Webster, New York, and your primary phone number is 585-377-7260, correct?
Yes, thank you.
That's 585-377-7260. And of course, I hired you. You've been working on our foils, and your Scopes hired you, and so has Gun Owners of America, Larry Pratt. So you've got 3 cases going for us, FOIL requests primarily right now, and some other cases. We'll get into those later. But I just wanted to make sure this contact information is over the. In this case, not over the airways, but on
over
YouTube.
Over the MP3s.
Yes. And scopeny.org, folks. Scopeny.org. Fire up Scope if you want up-to-date information on what we're doing. And Paloma has her own site. It's law-policy.com. Law-policy.com. And, of course, our Second Amendment website is 2ndamendmentshow.com. Check out those 3 areas, and you'll find a lot of quality information, accurate information. All right, so, Paloma, we left off on our other segment basically covering the governor for a few minutes, and we covered the basic SAFE Act, how it came about.
We did.
How we were defrauded, and it was basically a con job shoved down our throats. We had no input in it at all. We didn't have the 3-day debate, and they rammed it through. Okay, so this segment here, what happened from that point? Our counteraction, you and I are sitting in the studio right now with Doc. What did we do at that point after this happened? Go ahead.
Well, certainly preceding us in March of 2013 was the New York State Rifle and Pistol Association versus Cuomo lawsuit, which we mentioned. And in January of this year, of 2014, we started some Freedom of Information requests to the governor's office and to the New York State Police. And I think we thought it was going to be a fairly simple little exercise. I don't know that we thought we were going down the big litigation path.
Should have been a big operation.
Right. But, all of a sudden yesterday I'm submitting yet another 30 pages on top of a previous more than 200 pages. And, so all of a sudden our 3 Article 78 proceedings have really turned into major litigation. What's in Article 78? It's basically saying, okay, government, you didn't give me the records I asked for. Dear judge, please make the government give us the records. I mean, that's kind of a nice shorthand for what's in Article 78. And Judge McNamara, a Supreme Court judge in Albany County, has those cases. He happened to have been the same judge for Bob Schultz's lawsuit, which is now on appeal in the 3rd Department. specifically attacking the message of necessity. So here comes Judge McNamara in round 2 with our requests, which I believe as of my submission yesterday are now fully submitted, and we'll be, looking forward to some kind of a ruling. But, hearkening back to what we were talking about, this notion of the governor as a bad client for the poor attorneys, I do have some sympathy for the Attorney General's office on this one, because for the past 10 months, the lawyers and staff of the governor have been saying certain records don't exist. We've conducted a thorough search, and there's no records of any draft of the SAFE Act. There's no records of any staff working on the SAFE Act. There was no communication with the White House, or, this whole list of things that we asked for. There's none of it. And, I was slightly sarcastic in my administrative appeal to the attorney there for the governor. And I said, look, I don't mean to get sarcastic, but really, what are you trying to say? The SAFE Act just fell out of the sky in time for the vote. And essentially, that's the position that the state has taken. But once again, Governor Cuomo to the rescue in his autobiography, which in page after page after page goes on in some great detail and names different staff members he worked with, and that he called Superintendent D'Amico of the New York State Police, the second that events were evolving. So essentially in papers back to Judge McNamara yesterday, I quoted the autobiography and not only said, take your pick. I said, look, Judge, it's time for us to really get serious. I'm asking for sanctions against the lawyers. And that's a pretty big deal here in the state of New York. I think I've done it, maybe 3 or 4 times total in more than 20 years of litigation.
What sanctions would those consist of, Paloma?
It's a monetary fine against the lawyer. But
could it be substantial?
Well, yeah, there are decisions that go upwards of $100,000. I mean, it could be painful. I don't know that the judge will go that far, but I thought it was very important to signal both the judge and the public, because these are public lawsuits, that this is a pretty serious level of misconduct by somebody. Whether it's the governor himself trying to create sort of this conspiracy environment within his offices that no paper should be released to the public for us to do a review of the office, which certainly is our responsibility in a democracy.
Is it not somewhat remarkable the extent to which in New York State that these foils are being ignored? I mean, it's unprecedented, is it not? Yes,
it is a serious problem. And even Donald Trump has filed very recently quite a significant FOIL Article 78 lawsuit as well, equally claiming problems on things like real estate deals. So it's not even just the governor's office or just the New York State Police. It really is a pervasive problem across
cultural.
Many of the agencies.
It's normal
within
business.
state government.
Normal business for the state of New York.
Yes.
And we're looking at over 2,000, Doc. Right, Paloma, was over 2,000 FOILs they have not responded to, and they absolutely will reject, they won't answer. Over 2,000 throughout the state of New York, we're told.
Well, I think that no. That was just the New York State Police just in the first so many months of 2014 in terms of the number of FOIL requests they've received. So, I mean, that does give you some idea of volume, but I think, I'm speculating here, but I would think New York State Police numbers post-SAFE Act have spiked significantly.
So we're looking,
right?
Could be double, triple that.
Because let's face it, they are stuck with implementation of this thing on the ground. Mm-hmm. And I suspect with very little direction from the governor, I think that, the governor thought the SAFE Act was going to be this miracle thing that he was going to do. Everybody was going to love him. I don't think he thought about the next step. And that's part of what we're trying to understand here through the FOILs is we've received a whole now segment of responses from New York State Police saying there are no records of things like officer training on the 7 and 10.
How could there have been given the timing of this?
Yeah, but you've had 2 years
had a lot of
to
time.
implement your standard operating policies. So, part of what we did with the FOILs was take that New York State Police field guide that had gotten issued September, I think, of 2013.
Yep.
And we asked a number of questions. For example, how will the state police be determining if something is a nuisance weapon, that's their language from the field guide, subject to immediate destruction upon seizure, or a firearm that they're going to book and hold, and how then do we ensure that our firearms are preserved while we're off fighting the court battle to try to win the release of the firearms back to us as lawful gun owners.
And this is far more than just kind of an anecdotal or circumstantial discussion of the fairness or lack thereof of some unpopular statewide legislation. There's a constitutional issue here that basically says that any law which is arbitrary or capricious in terms of enforcement or interpretation is, by definition, unconstitutional. Isn't that right?
Right. And, so that's part of what we're trying to drive at here is we've got both lawsuits going at the constitutional issues and then also lawsuits going at the practical day-to-day implementation
procedural
questions. Yeah. Exactly.
Well, the other question our listeners have, I get hit with all the time, is how can the government suddenly decide that something I bought legally yesterday, totally legal, own it, it's my personal property. There's the New York State Police, as an example, could come in tomorrow and take my personal property from me without paying for it, without
any
due process, and then call it, as you mentioned earlier, a nuisance. Call it a nuisance and destroy it at their own will. I mean, this is out of control, potentially out of control government to be allowed to something like that, to be allowed to give them that kind of power. They don't have that kind of power. We shouldn't allow the government to have that kind of power without going through the full court process. And a judge finally saying, and a jury saying, okay, this is a nuisance. A nuisance. This pen I have in my hand's a nuisance. It could be a nuisance if they want it to be. So this is outrageous that we've allowed that to happen.
I don't know that we have as much allowed it to happen as we're working our way through the court system with things. So imagine, if you will, that we've got two sets of train tracks with two completely different types of train. So envision your NYSRPA versus Cuomo as sort of the bullet train, right? It's the big con law question. It's whether the assault weapons provision is unconstitutional under the Second Amendment. If it prevails, the provision gets struck down. At the same time, we've got kind of this whole system almost of lots of subway cars that are interconnected, where we've got individual people, like a couple different folks in Wayne County, a couple folks down in Erie County, who are getting picked up, and firearms are mistakenly, initially by the officer on the ground, being called an assault weapon under this penal law provision. And they've got to work their way through the system. They're getting their firearms returned. So far, we're having these sort of day-to-day successful outcomes, trying to sort of hold the fort, while the flyover is happening to try to take down the provision.
Yeah.
So
the New York State Rifle and Pistol case, can you just say that in a nutshell, what that's about, so our listeners know what that one's about?
Sure, yeah. I mean, we have two really huge constitutional law questions right now, and they really are the extension of the Heller decision. So we have this question about whether the assault weapons provision here in New York amounts to either an effective ban on certain types of firearms.
Bob Savage is the human footnote here. The Heller decision is the D.C. Circuit Court that basically struck down the handgun concealed carry ban in Washington, D.C., right?
Yeah, so you've got Heller and McDonald as two companion cases 2 years apart. One says the Second Amendment is a fundamental right, and the other says that applies equally to restrict the states from inappropriate legislation.
Got it. Thanks.
Yeah, so you need that kind of handshake, because the second requires the 14th Amendment to pull it across to the states. But, there's this other huge question in this lawsuit, and that's what is the standard of review that the court will ultimately settle on to analyze these statutes. We are, of course, hoping for strict scrutiny. Because when you say, how can the state get away with essentially an ex post facto law, criminalizing something that was previously legal, the state has to win the argument that what they have done has a legitimate safety outcome that is demonstratable. And if it's a strict scrutiny standard, that, of course, is much higher than an intermediate scrutiny standard, which is what the state wants. Under intermediate, basically you say, it could just help 3 people up the road, maybe kind of, sort of. I exaggerate to some degree, but intermediate is just very wishy-washy. It's not what we want. We want strict scrutiny, where if Cuomo's message of necessity and the accompanying memorandum to the bill say that he's going to reduce specifically the risk that a mass shooter emerges again in the future in the state of New York, he demonstrates a direct link between going from 2 features to 1 feature, the specific features itemized, and the decrease in probability that we'll see another mass shooter. He can't do it.
I was going to say, how can you make that case?
There's no way to make it. It doesn't exist.
Yeah.
Right? It doesn't exist, and it's not factually correct. So we're back to your word of the morning. Bill's word of the morning seems to be accurate. And that is where the state's case falls apart in NYSRPA versus Cuomo, Malloy versus in the Connecticut case, and O'Malley, which is the Maryland case. All 3 cases fall apart. There is no evidence to suggest that any of these statutes in any way help to keep us safer from the specific type of crime that they're looking at.
Yeah. Well, we covered this on our Second Amendment show with Paloma last week. Say I have a Mini 14. A Mini 14, in case you're not familiar with that rifle, it's a Ruger Mini 14. It shoots a .223 round, just like the AR-15s do and the M16 full automatic weapons that the military has, where they're not allowed in New York State full autos. We covered that on our show briefly. But semi-automatic AR-15s are not any more dangerous than a Mini 14. But a Mini 14, which is a semi-automatic rifle, is okay because it's not black and it doesn't have a pistol grip.
Protruding pistol grip, yeah.
No pistol grip. Now, as far as I know, the criminals I've studied in the past, I've done security for many years and worked armed security in the city of Rochester on hundreds of occasions in different establishments. We're not getting any threats with AR-15s because they have a pistol grip. They're walking. They choose a pistol grip to come in and take the local liquor store out or shoot up a dance hall or shoot up a school. They're not picking. These psychos that do these killings are not picking an AR-15 because they have a pistol grip. So what does the state do? They ban a pistol grip. They don't want to see a pistol grip. So a semi-automatic is a semi-automatic rifle, no matter what, is a sporting rifle. And this is where we're having problems, and they're going to have a real problem, the state of New York, trying to justify that.
Well, and back to the Article 78s, this is also where I think the New York State Police and the governor's office really doesn't want us to know what's going on. I mean, among the requests that we made were for drafts and previously published versions of these pamphlets that they have on this official SAFE Act website, and they won't release them.
Yeah.
Okay. Look, if you are having a problem yourselves deciding which firearms are lawful and not under the SAFE Act, I think we need to know that too.
Yeah, and by the way, the AR-15 is the most popular gun ever in the United States. #1 seller nationwide, totally legal in 99% of our states, virtually all of them, with some slight adjustments in a couple of states, other than what's recently been passed in Connecticut and Massachusetts. Anyway, the bottom line is the most popular gun ever in the United States. Millions of them sold, basically, and they're not allowed now in the state of New York. This is outrageous.
But that's where we're back to. What is the real agenda here?
Exactly.
The agenda here is government control.
Government control, folks. That's what it is.
It's not public safety.
So, anyway, I wanted to cover that. I'm glad we covered that angle. The other thing is back. We got a couple minutes left with this segment. The New York State Rifle and Pistol lawsuit overall,
yes.
What was that? What is that? What are they trying to do? If you were going to say in a couple of sentences, what's their mission on that lawsuit?
Oh, sure. They're trying to strike down the assault weapons provision at New York Penal Law, Section 265.00, subparagraph 22.
Okay, that's it. Then that's the purpose of that.
Just in case the folks listening want to rewind on that. Yes.
Yeah, because everything we do, we have to have it all well documented and everything dead on.
That's the provision. That, if you will, that would be the sniper shot into the SAFE Act.
Okay.
That is the most important provision to the governor, bar none.
Yeah. So,
the assault weapons ban, and the irony, of course, being here for the uninitiated listening to this audio file, is if you were to walk into American Sportsman or any local gun store and ask for an assault weapon, they're going to look at you like you're from another planet, because technically there is no such thing as an assault weapon.
Right.
This is a concocted term. Through I'll call it a cabal of media and government, to make a certain class of weapon sound like something it's not, for marketing purposes.
Yeah, these are the big, black, scary guns, right? Going back to Senator Feinstein and the 1994 assault weapons ban.
The Democrat Party, Doc, has developed this bugaboo about these black guns with a pistol grip. I mean, you have why do people buy the AR-15s? And a lot of women buy the AR-15s and have them for personal protection because you got
to control.
Good control. You got accuracy. It's a nice, comfortable gun to shoot and have fun with at the range. Target practice with.
Reasonable amount of recoil. It's not. Not
there's
a big
virtually
kick.
almost no recoil. You can shoot it from the hip. The women out at our ranges shoot them right from the hip. It's not a high powerful
or small guy.
What do you want
to
to call it?
Politically
Large
correctly.
caliber or powerful round. It's a mid range round. It's not a real like a 30-06 is really powerful. 308s are powerful.
So let's just toss then one more thing on the table here to be sure that just in case Andrew, and I'll say that in a nice silky radio voice, just in case Andrew has tuned into our broadcast, manufacturers of firearms do not sit around trying to figure out how to circumvent the law. If I hear that argument one more time, it's a product that we love and that we revere as Second Amendment supporters, but it is a product. And as a product, it's going to evolve. What's popular? What's trending? Who's buying? I mean, for example, a pink handgun? Who knew that was going to be released? And mind you, ladies, if you're listening, just go black already. Just, skip the pink, right? We are as good, if not more accurate, than our male counterparts at the range. So, go black, go big, go scary. After your first round, that's done. Just, you'll fall in love too. But I think that, the argument of the left that somehow manufacturers are the devil incarnate of trying to circumvent the law and feed firearms to criminal is really slanderous in its approach.
Yeah, it is. All right, so we'll wrap up this second segment, and we're going to go on to our third segment. And any loose ends before we wrap this one up?
No, it's just to say, if the judge is listening, I hope I've given you some good oral argument to add to the persuasion and that you rule in our favor.
It's ex parte radio, and you're picking up on it here online. We'll be back with more Second Amendment, a special conversation with Dr. Bill Robinson and Paloma Capanna. We continue our conversation here on Second Amendment Radio Online with Dr. Bill Robinson, co-host of the Second Amendment Radio Show on the WYSL stations, and our special guest in studio, Paloma Capanna, Esquire, Second Amendment attorney. Bill?
Yes, we were having a chit-chat. We're doing 3 sessions, putting 3 separate, roughly 20-minute segments together, just to cover loose ends and to get the facts straight to our listeners on this station, on WYSL, and on the ones that tap into our Second Amendment website, 2ndamendmentshow.com, and those of you that are Scope members and those that are interested in joining Scope, scopeny.org. Check that out, scopeny.org, and Paloma's website for up-to-date information, research on the Second Amendment issues is law-policy.com. Law-policy.com. I'd fire that up every couple of days or so and see what the latest is if you're into this. And there's a lot going on. And a lot of us out here are quite concerned, Paloma, that we are potential felons. There was 3 of us in the studio right now.
2 of us, anyway.
Yeah, but even you with the rifles. Some bogus.
Excuse me. Wait.
I don't want to be left out.
Let me be clear about something here. I have no firearm in my possession that violates the assault weapons provision. I just happen to have a, shall we say, weakness for long-range
The catch is
rifles.
Because the state troopers, as we said earlier in another segment, are not trained in this.
No,
they could, by accident, say your gun's illegal, and they're going to scoop it up.
Possibly.
This is the power we've given to the state police, allegedly given to the state police. We'll see how that's going to.
But I think one of the little intimate details of all of this that perhaps we should bring people into is for any of us who are out front on these issues, we are at risk. But I think the question is, how would they come for you? For you, it's yank the airwaves license. Right. For me, it's yank the law license. Mm-hmm. I mean, I think truly if somebody's coming to try to shut down the arguments. They're coming to take away our voice, even more so at the present minute than our individual firearms, because the voice for right now is really the potent weapon in this fight to push back the SAFE Act, to get people unelected who have been re-elected and shouldn't have been. So, the voice.
That's what regulation of the internet is all about too, because the internet is that is the battleground. That's where all the really good investigative journalism, frankly, is taking place now. The outlets that we used to rely on, the major TV news outlets, the networks,
the FCC license,
the daily newspapers, forget it.
Right.
They're all in the tank for government these days.
And they are all representatives in promoting the Democratic Party, day and night.
They're
agents of the Democrat Party. It's that simple.
If you'd like to understand, gain an understanding by this, a little aside here, of the extent of this and how out of control this is, must read on your bookshelf this winter is Cheryl Atkinson's book, Stonewalled.
Yes.
Her experiences with as a CBS news person. She's the one who was very involved in the Benghazi coverage, very involved in Fast and Furious, and what happened, the dynamics of what were going on with CBS and its ties to the White House. I mean, the White House bureau chief was the brother of a White House press operative.
Yeah, they're running
in
cover.
the Obama administration.
And it's not just CBS. They're running cover. Most of these.
That's right, Bill.
They're running cover for the president. They're hiding things. They're protecting him. And they are, as I said earlier, agents, in effect, agents of the Democratic Party. Period. They are. I mean, it's well known. Everyone knows it. That's the way it is. And so we have to deal with that. And thankfully, we have this radio station, WYSL, and we have the internet to counter these lies, this disinformation that's going on out there, especially on our gun rights and our Second Amendment, the Second Amendment issues. And that's why we're here with Paloma again. And just in case this is the first segment you've tuned into or tapped into on our website, I want to mention again to check out scopeny.org for updates on the Second Amendment issues, law-policy.com, and 2ND, the number 2NDAmendmentShow.com for updates on the latest Second Amendment issues. And, of course, tune into WYSL for the Second Amendment Show and the Homeland Security Show and Bill Nojay Show. He's covering guns all the time, and the girls at noon on our shows. And why am I saying this? Because we're doing a separate segment here. Is because our listeners will fire up these websites from around the world. And they should be listening to our radio shows and getting updates on daily updates on what's going on.
Your shows are all available in podcast form too. So by definition, our listeners today are having kind of an intimate one-on-one listening experience because that's the nature of listening to audio files on the web. But you can do that with all those broadcasts that Bill just very kindly plugged for us. Just go to WYSL1040.com. You go to the podcast page and click on the appropriate link, and you're good to go.
Yeah, this is serious stuff. We're countering the disinformation out there. This station is a major player in countering the lies, the disinformation, the outright con jobs that's being perpetrated on us Americans today. And not just us in the state of New York, it's across the country. This station single-handedly is the most effective counter to this disinformation and lies, outright lies going on in the United States today, and especially here in New York State. Anyway, I wanted to talk with you, Paloma, about we were covering off the air, not taping here, video, well, not video. What do you call this officially?
Just it's audio file.
Audio file, what we're doing today. We talked about standing and being... because people, you run into these, you go to these meetings like you were at one the other night, Saturday night. People are mad. What's going on? Why aren't we doing this? Why aren't we doing that? Why aren't we suing more? Mm-hmm. You need standing, as you mentioned. What's standing and why do we need this? And the fear of arrest, that kind of thing. You have to have a legitimate reason to go to court. Something solid.
You do.
Easier to work with.
Do.
Go ahead. Tell our listeners. Talk about that for a minute or two.
There are sort of two footprints to how these cases happen. On the one hand, you can do them as a sort of theoretical question that a person has been chilled and is afraid of losing their constitutional rights or of being incarcerated and so forth. But for me personally, I've always preferred the footprint of a lawsuit with an actual person.
Yes.
Who has already suffered some kind of harm. I think it's just a very different narrative that makes the case personal to the judge. What that, however, requires is that 1 in a million person
Okay.
who not only has the legal arguments to make, but the courage to become a constitutional litigant, potentially for a period of years, potentially having their own life pulled apart and scrutinized.
Absolutely. People will be looking at you.
Yeah.
The media will be looking at you.
Yeah, and just that real clarity, I think, of morals and values that will say, well, if I'm the person, so be it, let's do this.
Yeah. All right. Now, we brought this up and talking a little bit about this. Now, your recent case with the mental health issue, because it's bugging a lot of people in the state of New York, the HIPAA and what's going on. You got to get a pistol permit now. You got to write down information there, and they have to do a background check on your mental health background, which they've been doing right along, but now it's more in depth. Anyway, go ahead. Tell our listeners what's happening now with your recent lawsuit and why you're doing what you're doing.
Yeah, just literally last week, we filed a brand new constitutional law case in the Western District of New York. It's been assigned to Judge Saragusa, and the name of the case is Montgomery versus Cuomo. So the plaintiff, my client, is Don Montgomery. He's a veteran. He served 30 years on law enforcement with distinction and honors and retired, and he couldn't sleep. You know, who of us has not had some sleepless nights? Presented himself to his physician, who recommended, please go to the emergency department. He goes on a Friday. He's there less than 48 hours, sleeps like a baby. Hospital staff love him, 76 pages worth of medical records, and everything's fine. Until 2 days later, when he gets a phone call from one of his colleagues who says, Don, we got to come pick up your guns. The hospital had tagged him as an involuntary commitment. He was not involuntarily committed. He has no mental health history. He has no medical history.
That was a mistake, right? We need to say that, right? On the part of the hospital.
Absolutely. Although the hospital is saying they won't change how they have coded him.
Oh, boy.
So the hospital, needless to say, is one of the co-defendants on the lawsuit. But equally, the sheriff's department in this instance essentially took the approach that the New York State Police were calling repeatedly and that they had to do this. So the sheriff's department didn't serve the function that, we think they are generally serving on the county level of independently evaluating our Second Amendment rights and sort of holding the fort as almost a tension point, if you will, with the New York State Police. So Don actually took it upon himself to contact the NRA General Counsel's office, who referred him across to me, and thus began a little bit of an odyssey. I had been researching already into the mental hygiene law, Section 9.46. This is a new provision that came in as part of the SAFE Act. This mandatory reporting provision that the Office of Mental Health for the state of New York is selling to practitioners as the best thing since sliced bread. And what we came to find out is that essentially it functions like this. You go to the mental health provider. They report you to OMH. OMH reports it across to DCJS, the Department of Criminal Justice Services, who reports it across to the New York State Police, who reports it across to the county clerk and the local licensing officer. Now, the state is going to say, there's nothing confidential about any of this. And that's total malarkey. I mean, we're being recorded. I'm just going to try to be polite about this, because if you were sitting here, people in the studio, you'd see my cheeks are like flaming red. All the Irish is coming out in me. Because what is it that gets transmitted? Your mental health diagnosis. What is it that gets transmitted? An expandable box field where the practitioner can write anything they would like about your current presentation, about your history, about anything. So we've got a situation where, by best estimates, more than 60,000 people have had their personal health information now sprayed all over the state and county level. And all but approximately 287 people, according to the New York Times, are not even aware that they've been reported. Those 287 people are pistol permit holders.
Oh, there you go. Yeah.
right? So what's completely bizarre about this entire scheme that the governor cooked up is that there is no notification provision. There's not a minute in all of your personal health information flying all over the place that anybody is required to tell you they've released your information. And in Don's case, when we went back to Eastern Long Island Hospital to say, well, where in his medical chart did you indicate this? The essential response was, we don't keep records of that.
Oh, really?
How convenient is that?
And when we went
Yeah.
to each one of the state agencies with a Freedom of Information request signed by Don to say, please send me whatever you have on my 9.46 reporting, they all came back and said that was confidential information they couldn't release.
Oh,
I
there
kid
you
you
go.
not. Who could make this up?
Yeah, we've definitely gone down
make
the
this
rabbit
up?
hole here, have we?
We have.
Oh, wow.
We have. Because what essentially have you got? You've got the governor attacking the right through the assault weapons provision to turn us all into felons.
Yep.
And the governor attacking the left through the mental health provision. And the reason I say it as the left is because, you've got 60,000 reports and only 287, less than 1% are pistol permit holders.
Mm-hmm.
To me, that becomes a left-driven issue in terms
Absolutely.
of privacy leading the argument even over Second Amendment.
I think it cuts across political lines, frankly.
Absolutely.
I mean, who doesn't value the privacy of their medical records? And once again, I mean, not to digress here, but the Affordable Care Act, the gift that keeps on giving.
Well, my big fear here is the electronic medical record.
Yes.
The drive that all of our records should simply flow across these electronic gateways without us even definitely knowing who all is signing into it.
Yeah.
I mean, circle back to our Article 78 cases for a minute. Among the documents that we requested, who are the personnel building these databases? What are the security clearances these persons are required to have, and so forth on down the line? And the state has come back with no records. No records, meaning you have not developed any metric or any standards through which you're going to be handling this highly sensitive personal health information?
Yeah. How easily is it going to be hacked? We got that happening all the time.
Well, haven't we seen that at least as far as Obamacare is concerned, that the security is non-existent? It's again a big rush to try to get this legislation implemented,
Right.
and not enough time to develop the security measures that a basic website would require.
Well, and the tricky bit here is I think that it goes further. We've argued in our complaint that the state is affirmatively misrepresenting to the medical health profession that this is not a violation of HIPAA. HIPAA has a companion called high tech, but and then there's breach protocols and so forth. But everybody sort of bundles it under just calling it HIPAA for efficiency's sake. HIPAA really dictates the security parameters for a hospital, for a doctor's office, for anything called a covered entity or their business associates. And failure to abide by those specifications can lead to very substantial penalties, financial, and incarceration. But OMH is actually selling this program to medical providers as completely compliant with HIPAA.
Yeah. Well, this is outrageous what's going on. So thankfully you're hitting him with this lawsuit, and hopefully we'll get this cleaned up here in the next, probably take a year to resolve this, right?
Well, stay tuned,
Maybe
because
more.
somewhere within the next 2 weeks, we'll be filing a motion for an injunction for the immediate shutdown of the ISARS reporting system.
Great. Good,
So,
do that. Yeah.
there will be New Year's Eve fireworks, and then there will be Montgomery versus Cuomo.
All right. And then with the remaining minutes, we've got a couple loose ends. One is this New York State Police hotline. If you have a question or problem on, say I have a rifle home and I'm not sure if this is legal or not legal by them, by their standards now, there are new standards that this commission decided, what's good for us, pats us on the head. Well, this gun you can have and this other one you can't have. So, Fred from American Sportsman, as an example, out at East Rochester, he's called there on a Monday, say, just on a Monday, he gets an answer, a specific question. He asks them, and they get a specific answer. And then he calls them back on a Friday or the following Monday, and they get a different answer. So this has been going on and on and on. So we're saying, folks, now it's time to shut down this hotline, the New York State hotline. It's a joke. They're putting out disinformation, wrong information. They don't know what they're doing. So it's got to be shut down until we get through these lawsuits.
Right.
And
so
resolve this.
If you're
It's gotta
fired
be
up
done.
with us after these segments, your grassroots activism is call the governor's office today.
Yeah. Call
To
the
call for the
governor's office.
shutdown of that hotline.
Call Senator Roebuck, call Senator
call
Rich Funky,
whoever.
call
I
Assemblyman
mean,
Bill Nojay. We want the hotline shut down.
Anybody who represents you, I mean, people all over the state and outside of New York State, obviously, can listen to this file. So you call your state delegation, you call your assemblyman or your senator, and you start lobbying for this.
Yeah, we want it shut down. We can't tolerate this the disinformation going out with this commission. We got basically a bunch of anti-gun liberals, Democrats mainly, out of New York City that are controlling this commission. It's time to shut it down, shut this New York State police operation down, because they're not New York State cops per se even answering some of these calls, is what I've been told, even though it's supposed to be.
Our understanding is that it recently shifted over to literally like an 800 call center.
Yes.
Unscripted,
Unbelievable.
untrained.
Isn't that something?
Are you kidding?
And it's a fiasco, like the Cobus check, the other one we had that we finally fought that for several years and got that thrown out.
That's
60,
dead, right?
70,
Okay.
60, $70 million the state of New York spent on this bogus shell check. They have to fire a couple of rounds off, and then you go and have them put down there to give them to the state police, and they store these shells. Well, they're getting so many false positives that they had to throw it all out and just dump it. Well, they're doing the same thing with the SAFE Act. It's a total waste of time and money and energy, and it's harassment on us. It's harassing us day and night. Many of us are fearful that we're going to get busted on some bogus voodoo gun charge. We've had it up to our nose with this nonsense, and that's why we're suing. Now, in the last few minutes, Paloma, where do we stand with you and I stand with our foils, GOA and scope foils? Where do we go from here? When are we going to go to court again? Just tell our listeners what's going on and our people that tune into this.
For the Article 78s, I think, everything is submitted now on paper. I don't know whether the judge will want any oral arguments or an attorney conference, but I would expect that we'll see a ruling very shortly on that. It's, if you will, not one of the federal lawsuits. It's a smaller Article 78 case. So I expect that he will rule fairly promptly on whether the state is required to provide certain records to us, whether we will be entitled to an attorney fee award, and potentially whether there will be sanctions against the governor's attorneys.
And my specific 15 questions I wanted answers, and GOA and scopes, we're looking at what, 2 weeks, 3 weeks, and maybe a month before we go to our next step?
Well, I have to call the court Monday perhaps to check in relative to whether the judge wants to see the attorneys. Okay. But say by end of January, we should have some kind of a ruling in that case.
All right. Well, very good. Doc, any loose ends before we're off the air here?
No, it's your show.
All right,
Very, very
bounce it off.
informative. The one thing I would pass along is let your friends know about the existence of these files. Send them a link.
Yes.
Refer them to the website so that they can get this valuable information, because these are things you need to know.
Yeah, we've got to be right on top of this. Again, we're all potential felons. And even you, Paloma, whether you don't have one of these
Paloma doesn't
dangerous
like
guns,
that.
it doesn't matter. You don't want to hear that.
No, it's not that, but wait.
Bogus.
It's not so much that
I
gotta, Bill and I now know each other so well. He's, glasses half empty, I'm half full. It's not so much that we are all potential felons, it's this. This is a really particular second in the minute of the history of the Second Amendment. And we do have a job to do in defending it.
Yeah.
So if you are sitting out there and you think you are a potential litigant and you would like to be the next Rosa Parks, I mean, to some degree, that's what it's going to take. There are other provisions from within the lawsuit that we are ready to file when the right person comes forward with the right circumstances and narrative and the will to get the job done. So let's all do our patriotic duty. The line of fire at the moment is the Second Amendment, and we have to hold it safe.
Yeah. We owe it to our kids and our grandkids. Thanks for checking out the file. Tell a friend about it, and be sure to listen to Second Amendment Radio. Thank you, Paloma. Thank you, Doc.
Thanks, Doc. Thanks, Bill.
Thank you. Thanks.
Take care.